Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Jerry Curington. Jerry is former General Counsel for the Department of Transportation and is currently practicing in the Tallahassee area. Jerry is going to be speaking with us about matters dealing with torts in the state of Florida. Jerry, welcome.
Thank you very much. I'm very pleased to be part of this innovative program by the Division of Young Lawyers.
Well, we're certainly happy to have you here. Let me run this hypothetical by you. Say I have a client who suffered damages from a car accident caused by a state employee who was on duty and acting within the scope of his employment at the time of the accident. Can my client sue the state for damages, notwithstanding the state's doctrine of sovereign immunity?
The short answer to that is yes, absolutely. Let's start with the moment with the very doctrine of sovereign immunity. As we all remember from law school, that is the principle that the government cannot be sued without its consent. The Florida Constitution, Article 10, Section 13, however, gives the Florida legislature the opportunity to waive sovereign immunity. In 1973, the Florida legislature did precisely that in passing Section 768.28 of the Florida statutes.
Are there any special procedures that are required when suing the state in tort?
Yes, absolutely. First of all, you must comply strictly with the prerequisites of 768.28. They are considered conditions precedent and must be followed closely. For example, you must present your claim to the agency the employee works for and to the Department of Financial Services in writing 6 months before you can file suit. Understand that the state of Florida is self-insured, and the Department of Financial Services, through its Division of Risk Management, acts like any other insurance company. It has in-house claims adjusters and on occasion retains private claims adjusters to evaluate these written claims. It has 6 months to decide whether to settle the lawsuit. If it doesn't act within the 6 months, then you can file your suit in court.
Are there other things I should consider or be aware of when suing the state for a tort?
Well, yes, there are a lot of procedural things. So let me start, first of all, with a different statute of limitations. It's a 3-year statute of limitations for bringing that notification to the state. If it's a wrongful death case, you only have 2 years. Okay? The suit, like many suits, are subject to the rules of venue, and although you may have heard of the home venue privilege, where the state normally has the right to be sued in Leon County, 768.28 provides for venue either where the causes of action accrued or anywhere where the state defendant agency has an office. Okay, so there are more venue choices than in some other matters. You do not name the individual state employee. So in this hypothetical of a car accident, if the driver is John Doe, you do not sue John Doe or name them as a defendant. Rather, you name the department that John Doe works for, or you can name the director or the head of the agency in their official capacity, but you cannot name the individual. Now, there is an exception to that. You can name the individual if you want to allege malicious or wanton or willful conduct. But I would caution you before you do that, that if you do that and prove it, the state may not pay the judgment. So you need to be careful what you ask for and be careful what you plead. The waiver of sovereign immunity does have its limits also in that you can only recover up to $200,000 per person or $300,000 per incident. If you have a settlement or a judgment that awards you that amount, you can collect it from the Division of Risk Management. However, if your judgment is larger than that, or any settlement is larger than that, and agencies can agree to settle for more, you must present the balance, any excess over the $200,000, $300,000 limits, you must present to the legislature in a claims bill. That is a unique process and really the subject of another discussion for another day. Understand that when you do get judgments against the state, they may not be enforced by filing liens against the state or writs of execution against the state. Many of the common law equitable remedies are not available to the state. So you cannot assume that estoppel applies against the state or quantum meruit or other equitable theories will apply. Keep in mind, you cannot recover punitive damages from the state either. One thing to keep in mind is Florida has passed the Sunshine Litigation Act. If, in fact, you settle, you cannot have confidentiality terms. We're all familiar with Florida's public records and sunshine in meetings laws. Any settlement provision that ostensibly provides for confidentiality is null and void as a matter of law. And that's provisions 69.081 of the Florida statutes. Also understand that in suing for torts, the waiver of sovereign immunity looks at torts of two natures. Either they are planning level decisions by the agency or they are operational. The waiver only applies to operational. So if the state driver is speeding or violates traffic laws, you can sue. But if that accident was caused because of the angle of the curb or there weren't enough warning sights, those are policy level decisions, and the state remains immune from suit in that regard. If you'll excuse me 1 minute, I'm leaving out some sites, and I don't know how maybe we can address that. But that in a nutshell, I think, are some of the key provisions that apply when you sue the state and would not necessarily apply in the private sector.
Thank you, Jerry. You certainly provided a lot of very useful information here today. And just keep in mind that this video is filmed in 2014, so should you need to use any of the information that Jerry's provided to you, make sure you shepherdize as well. Thank you for watching.